A Supreme Court chain reaction just changed how gun laws work in America, and most gun owners still have no idea. Pause. If you think the rules you learned 2 years ago still protect you today, that mistake could cost you your rights, your money, or even your freedom. Quick question before we continue. Are you subscribed? Because what I'm about to reveal could be the difference between staying legal and walking straight into a charge you never saw coming. Hit that button now, because gun laws are changing faster than most people can track, and this channel is here to keep you ahead of it. Here's what just happened. A lot of people think there was one single Supreme Court case that flipped everything overnight. Not exactly. The truth is bigger than that. Over the last few years, the court handed down several major gun decisions, and together they changed at least 9 legal rules that affect how you carry, buy, build, store, and even talk about your rights in court. And here's the part nobody's talking about. Some of these changes help gun owners, some do not. And a few create legal traps because people are only hearing half the story. So let me break this down for you in plain English, step by step, so you know what changed, what did not, and where people are getting burned. First thing, the old prove you need a gun more than everyone else rule took a major hit. This came from the Bruen decision. Before that ruling, states like New York could make you show a special reason to carry in public. Not just, I want to defend myself. They wanted something extra, a specific threat, a special danger, something unusual. The Supreme Court said no. If you are a normal, law-abiding person, your right to carry for self-defense does not vanish just because the government thinks your reason is too ordinary. Think about how huge that is. Imagine you live in a state where the sheriff or licensing office used to act like your personal bodyguard application had to be good enough for them. Maybe they liked retired cops, security guards, or politically connected people. But your reason? Not enough. Bruen changed that. Most people think that only mattered in New York. Wrong. It changed the whole legal map because it told every court in the country that the right to bear arms means outside the home, too. But here's what most people get wrong. Bruen did not erase permits. It did not mean every state has to go permitless. It did not mean training, fingerprints, fees, and background checks are automatically dead. That brings us to the second change. Objective permit systems still survive. In other words, states can still say, fill out the form, pass the background check, take the class, pay the fee, and we'll issue the permit. As long as the rules are clear and not based on some official's personal feelings. That matters because a lot of gun owners heard Bruen and thought, great, permit rules are over. No, that can get you in trouble fast. If your state still requires a permit to carry concealed and you skip that step because somebody online told you Bruen killed the system, you could still end up charged. Most people think the case was a total green light. The truth is, it was a red light for subjective systems, not every system. Third, sensitive places still exist, but the government cannot just paint whole neighborhoods with that label. This is where it gets interesting. The court said places like courthouses, polling places, and similar spots can be treated as special locations where carry may be banned. But it also pushed back on the idea that a state can basically say, this whole crowded city is sensitive, so no carry for you. That is a massive deal. Why? Because after Bruen, some states tried to work around. They lost the special need rule, so they started expanding the list of places where carry was banned. Parks, public transit, entertainment spots, restaurants, certain businesses, and more. Some of those laws are still being fought in court right now, so if you carry, you need to stop thinking only about whether you have a permit. You also need to ask, exactly where am I standing? Because legal in the parking lot may not mean legal inside the building. Here's a hypothetical example to explain this. Let's say you have a valid carry permit. You stop for coffee, then head to a government office, then swing by a stadium for a game. Same gun, same day, same permit. But 3 different legal answers could apply depending on the location. That is the kind of trap that catches normal people who are trying to follow the law. Fourth, private property rules became a new battlefield. Some states tried to create default rules saying you cannot carry on private property that is open to the public unless the owner gives clear permission. In simple terms, that flips the normal assumption. Instead of see area is okay unless posted otherwise, it becomes carry is banned unless the owner says yes. And here's the crazy part. This issue is still moving through the courts. So if you walk into a store, restaurant, or shop, you cannot assume your state handles that the same way your neighbor's state does. Have you ever wondered why 2 people can do the exact same thing in 2 different states and one is legal while the other becomes a criminal case? This is why. The Supreme Court changed the test, and now lower courts are still sorting through the details. If you're finding this helpful, imagine what you'll learn in my next video about the 5 words that protect you when police ask about your gun. Subscribe so you don't miss it, because these small details are the ones that save people from big mistakes. Now let's move to the 5th change, and this one surprised a lot of people. The Rahimi decision made clear that at least some people can still be disarmed without violating the Second Amendment. Specifically, the court said the government may temporarily take gun rights away from a person who has been found by a court to pose a credible threat to someone else's safety. In that case, the law involved domestic violence restraining orders. Let me say that carefully, because people keep oversimplifying it. The court did not say the government can disarm anyone it thinks is irresponsible. In fact, it rejected broad, fuzzy language like that. What the court focused on was a real court process and a real finding that the person was a credible threat, or that the order barred the threatened use of force. That is a narrower rule than many headlines made it sound. So what changed? Number 5 is this. If you are under a qualifying domestic violence protective order, federal gun possession bans are still very real. Not theoretical. Very real. That means guns and ammunition can both become part of the problem. And if you think, well, the order is just temporary, so this doesn't matter, that is exactly how people sleepwalk into a federal case. Imagine you're in the middle of a messy breakup. Tempers are high. A judge signs an order after notice and a hearing. You tell yourself, it is just family drama, and keep your pistol in the house. That can become a federal felony issue. Don't make that mistake. Now here is number 6, and this is the part nobody is talking about. Rahimi was narrow. That means it did not settle every gun ban in America. It did not answer every question about felons, drug users, young adults under 21, serial number S, or every so-called dangerous person law. Those fights are still happening. Some are moving through lower courts right now, so when somebody says the Supreme Court already decided all of that, be careful. Usually they are wrong. Now, quick legal note. This is educational information, not legal advice. Always consult an attorney for your specific situation. This matters because bad advice spreads fast in gun circles. One viral clip says, Bruen killed every possession ban. Another says, Rahimi proved the government can ban whatever it wants. Both are wrong. The truth is more complicated. Some restrictions are standing, some are falling. Some depend on how a court applies the history-based test from Bruen. And until more cases are decided, the legal map stays uneven. 7th, the bump stock rule changed in a totally different way. This came from Cargill. A lot of people thought the court would decide a giant Second Amendment question there. It didn't. Instead, it said the federal agency went beyond the words Congress actually wrote. In simple English, the court said a bump stock does not fit the legal definition of a machine gun under the current statute, the way the agency claimed it did. That is important for 2 reasons. First, it means you cannot just assume an agency can rewrite a gun law by changing the meaning of words. Second, it shows that some gun cases are not really about the Second Amendment at all. They are about whether the government followed the law Congress passed. But wait, there's something even more important. A lot of gun owners heard that decision and assumed it meant anything related to rapid-fire devices is now automatically safe. No, it means that specific federal rule was struck down under that specific definition. State L, may still be different. Future federal legislation could also be different. So if someone tells you Cargill means there are 0 legal risks now, that person is setting you up. 8th, ghost gun kits got hit in the other direction. In Bondi versus Vanderstock, the court upheld federal regulation of at least some kits and unfinished frames or receivers. So if a kit can be turned into a working gun quickly, using common tools, and it includes what you need to make it function, the government can treat that product like a firearm under federal law. This is where a lot of people are dangerously behind. They still think unfinished means unregulated. Not anymore, at least not across the board. If the product is close enough to becoming a gun, fast enough, hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the gun owners who get these updates first. Click subscribe, because these legal shifts don't come with warning labels, and the next one could hit your state before the news even catches up. Now let me give you number 9, and honestly, this is the biggest hidden change of all. The Supreme Court changed the question judges ask. That sounds boring, but it changes everything. Before Bruen, many courts used a balancing test. They would ask something like, does his law seem reasonable? Does public safety justify it? After Bruen, the question became very different. Now courts ask whether the conduct is covered by the Second Amendment and whether the government can point to a historical tradition that is similar enough to justify the modern law. Why does that matter to you? Because now every gun case is partly a history fight. Lawyers are digging through old laws, old cases, old traditions, and old analogies. That means outcomes are slower, messier, and less predictable. A law looked solid before can suddenly become vulnerable. A law people thought was doomed can survive if the court finds the right historical match. That is why the same week you hear one court strike something down, another court upholds something else. Here's what most people get wrong. They think Supreme Court decisions work like flipping a light switch. Illegal, then legal. Or legal, then illegal. In reality, it often works more like an earthquake. The main ruling hits first, then the aftershocks keep moving through lower courts for years. So what should you do with all of this? First, stop relying on gun counter gossip, old Facebook posts, or 3-year-old forum threads. Second, check both federal law and your state law before you carry, buy, sell, or build anything. Third, pay special attention to location rules, protective orders, unfinished receivers, and any device the government might classify based on technical definitions. Fourth, if you cross state lines, slow down and recheck everything. Your permit, your transport method, your magazine, your storage, and even the places you stop can all change your legal risk. Let me make this personal. Imagine you're on a road trip. You have a gun in the car. You think, I'm legal, I'm a good guy, I have a permit. Then you enter a state with stricter sensitive place rules. Or you stop at a business with a private property default ban, or you are carrying under a permit rule that does not travel the way you think it does. Suddenly, your confidence becomes evidence. That is why this matters. And this is the part that shocked me most. The biggest danger right now is not only hostile law, it is outdated confidence. People are acting on old rules in a brand new legal system. That is how good people get blindsided. Laws change fast. Court rulings change faster. Subscribe now because this legal picture can shift again the moment the next major gun case drops. And my next video breaks down exactly what gun owners need to check before they carry this year. So here's the bottom line. The Supreme Court did not create one simple win or one simple loss. It changed 9 major rules at once. Who can carry, how permits work, where carry can be banned, how private property rules work, when dangerous people can be disarmed, what Rahimi did not settle, why agencies cannot rewrite gun statutes, how ghost gun kits are regulated, and how every future gun case will now be judged. If you remember one thing, remember this. Most people think they are following today's gun laws when they are really following yesterday's. Don't be that person. Subscribe right now, stay updated, and share this with one gun owner who still thinks nothing changed. And final reminder, this video is for education only. It is not personal legal advice. If your freedom or your rights are on the line, talk to a qualified attorney in your state before you act.